Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is 1 August 2025, years after the Big Bang. Oh, sorry. No, sorry. The last ice age. No, hold on. I got it. I'm going to get it. Julius Caesar crossing. No, that's not it either. Publius Cornelius Scipio Africanus conquering. No, that. Um, Jesus, sorry, Jesus. Yeah, 2025 years after Jesus. Amazing. Here we are. It's a Friday, and we're back on the issue of gender and civil rights in Bostock versus Clayton County. We're in Gorsuch's opinion for the court, and we're in Roman numeral II, letter C, picking up where we left off in June. If more support for our conclusion were required, there's no need to look far. Why are we doing this? Why are we doing this? Anybody have an idea? We're doing it because this is called edumacation. Look here, I'm showing you how to get to it. Bostock. We're on, if you're not seeing this on YouBoob, you're missing out, buddy. You're missing out. We're in C. I just read the first sentence of C, but first let's talk about why we're doing this. You can follow along if you want, obviously. I mean, you know that. Well, why are we doing this? I want my students to see I've read all of this. And what I mean by read is not typically what they mean by read, what students mean by read. What I mean is I read it all, all, not just some, all. And this is not my first time reading it. This is not my second time reading it. These, you can see on this podcast that I actually read. And it's not the first time. And I read carefully, and I read critically, and I read closely. I'm modeling that for the students because they don't have anybody modeling it. There's apparently some kind of weird thing going around that you don't have to read. You don't worry about reading anymore. You can be prepared without reading. Just give me the summary. Give me the bullet points. There's all these shortcuts, allegedly. And I understand if you're pressed for time sometimes. I get it. I've been there many times. But it's no substitute for reading. So, if nothing else, this whole channel, when it's all said and done, no one can ever accuse me of not reading because you can see it right there. He reads. And there's a theme behind that if you're not getting it. And the theme is that we have to go back to basics. It's human nature to want to skip the basics. You can't skip the basics. And part of the basics is you have to read. There's no way around it. And I also want to give a sense for how long it takes. I mean, you people who want to do shortcuts all the time, well, okay. But to do it right, how long does it take? Do you even know? And if so, how do you know? Maybe you're making an assumption that the shortcuts are the same thing as doing it right. But what if you're wrong? What if you're instead teaching something that undermines education, that doesn't reinforce it? You ever thought about that? Has anybody ever said that to you? And I think that we have more time than we admit. The hurry up mentality is oftentimes imposed because we have other commitments that are not really thought through very well as far as whether those commitments really match the quest to be educated about something. So, something for you to think about, and thinking takes time. It takes resources. People are more likely to provide resources for you to do it if you do it right. And what we're noticing is there's a whole bunch of us that are reluctant to provide resources for continuing to do it wrong. Back to basics. And there's nothing sexy about the basics. Well, maybe that's how you feel, but I'm an educator, so I do actually think there's something sexy about the basics. All that the statute's plain terms suggest this court's cases have already affirmed. Consider three of our leading precedents. In Phillips versus Martin Marietta Corp., a company allegedly refused to hire women with young children, but did hire men with children the same age because its discrimination depended not only on the employee's sex as a female. Hmm. Did you just see what I just saw? I think I just saw it too. This word woman was equated with sex as a female. Interesting, interesting, interesting. Don't forget, don't forget. See, we're reading carefully. Just give me the summary. No, you got to learn to pay attention. You got to read carefully. You miss a lot. You miss a lot. Now, if you get the background full and rich doing it right, well, then you could get to a place where you can go faster. But I'm not going to model that because I think a lot of people try to model it, but they're taking a lot for granted. They're taking a lot for granted that there is background there when there's not. Because its discrimination depended not only on the employee's sex as a female, but also on the presence of another criterion, namely being a parent of young children, the company contended it hadn't engaged in discrimination because of sex. The company maintained, too, that it hadn't violated the law because, as a whole, it tended to favor hiring women over men. Unsurprisingly, by now, these submissions did not sway the court. That an employer discriminates intentionally against an individual only in part because of sex supplies no defense to Title VII, nor does the fact an employer may happen to favor women as a class. Okay, let's talk about that a bit. Let's translate that into multiple criteria that are sufficient. Okay. I'm gonna give a counterexample to this to show that this reasoning doesn't work. And I don't know how Justice Gorsuch would respond to this, but he's claiming that if you have any part of the decision, including sex at all, then that would violate the Civil Rights Law of 1964. I don't think so. Now, here's a strange example, I know, but these counterexamples are often strange, okay? So just play along. Let's say that the company finds out that the woman is a murderer. I know, I know. Just play along, okay? You'll see where I'm going in a second. The company finds out that the woman who's applying for the job or the promotion is a murderer. Now, maybe there's not enough, uh, evidence to convict. So, I mean, just get rid of the conviction issue, okay? I'm not talking about the conviction. I'm talking about the fact. The fact. Okay? The fact is prior to and independent of a conviction. Now, there's a man going up for the job, and he's also guilty of murder. I'm not saying conviction, I'm saying the fact. Why would they ever want to hire somebody like this? I know. Just imagine that there is a scenario where they want to hire somebody. This is Martin Marietta. If you don't know what Martin Marietta is, I grew up near Martin Marietta. It's in Colorado. It's in Colorado. Well, at least it was when I was growing up. It's a defense contractor. And now they don't hire the woman. And it's because they're going to hire a murderer, but you know, we'd rather not have a woman murderer. Maybe they think it's creepy for whatever reason. And it's less creepy when a man does it. Well, it seems like it would be a sufficient reason not to hire somebody if they're a murderer, right? I mean, it seems like that would be the end of the analysis. Um, Now, if let's say they do hire the man and they were mistaken, he's not a murderer, actually, they were mistaken. So they didn't really hire a murderer. They thought they might be, but they didn't. They just hired him because he's a man. And they are less creeped out by a man murderer than a woman murderer. I don't see how the fact that sex has anything to do with it really comes into play in the way that Gorsuch is saying. The because of sex thing. I just think you need to go a little bit further, and you have to get into the issue of what are the main requirements, or what are the main features that they're looking for. But let's go back to basics here. Again, he says women, and then he says sex as a female. He says women are female. That's what he says. So don't forget that in these examples. Now let's go to the next example, Los Angeles County. Now, if you didn't get the murderer thing, I'm just saying, according to Gorsuch, if you find out that she's a murderer and you don't want to hire a woman murderer, that makes it illegal not to hire her. I don't understand the reasoning there. To me, it doesn't make any sense. Just because the woman part is part of the analysis, but it's not the entire part, or it's not even the most important part. He says that doesn't matter as long as any little teeny part, like 1%, has to do with her being a woman, then that's an illegal action by the company. Um, let's go into Los Angeles Department of Water and Power versus Manhart. An employer, I got this printed out, so an employer required women to make larger pension fund contributions than men. The employer sought to justify its disparate treatment on the ground that women tend to live longer than men and thus are likely to receive more from the pension fund over time. By everyone's admission, the employer was not guilty of animosity against women or a purely habitual assumption about a woman's inability to perform certain kinds of work. Instead, it relied on what appeared to be a statistically accurate statement about life expectancy. Even so, the court recognized a rule that appears even-handed at the group level can prove discriminatory at the level of individuals. True, women as a class may live longer than men as a class, but the statute's focus on the individual is unambiguous, and any individual woman might make the larger pension contributions and still die as early as a man. Likewise, the court dismissed as irrelevant the employer's insistence that its actions were motivated by a wish to achieve class-wide equality between the sexes. An employer's intentional discrimination, here we are right here, an employer's intentional discrimination on the basis of sex is no more permissible when it is prompted by some further intention or motivation, even one as prosaic as seeking to account for actuarial tables. The employer violated Title VII because when its policy worked exactly as planned, it could not pass the simple test asking whether an individual female employee could have been treated the same regardless of her sex. Okay. Again, we're talking about individual female employees. We're talking about sex, and yet he uses the word woman and women. Fascinating. Almost like those two things are the same thing. I mean, not that I disagree. I'm just pointing it out because it might come in handy later. You want to notice this stuff. In on scale versus sundown offshore services, a male plaintiff alleged that he was singled out by his male coworkers for sexual harassment. The court held it was immaterial that members of the same sex as a victim committed the alleged discrimination. Nor did the court concern itself with whether men as a group were subject to discrimination or whether something in addition to sex contributed to the discrimination, like the plaintiff's conduct or personal attributes, or whether he was guilty of murder. I added that last part in there. Assuredly, the case didn't involve the principal evil Congress was concerned with when it enacted Title VII. But the court unambiguously explained it is the provisions of our laws rather than the principal concerns of our legislators by which we are governed. Because the plaintiffs alleged that the harassment would not have taken place but for his sex, that is, the plaintiff would not have suffered similar treatment if he were female. A triable Title VII claim existed. The lessons these cases hold for ours are by now familiar. First, it's irrelevant that an employer might call its discriminatory practice, how others might label it, or what else might motivate it. In Manhart, the employer called its rule requiring women to pay more into the pension fund a life expectancy adjustment necessary to achieve sex equality. I hope that you're catching this. Are you catching some inherent tensions here? If so, what are they? Now, Gorsuch thinks he's on the correct path and he's not touching any part of the swamp as he navigates through these tensions. But I think his feet are wet. I think he's touching the swamp. I don't think he's clear here on the path. And as we'll see when we get to the dissents, the Republican dissents, you'll see that there's a Republican split here. And that's what this whole thing is about. We're going to get into that. We're almost done with we're getting through this. We're going to go through to Roman numeral III and do a little bit into Roman numeral III before we end today. And then there's only a couple other sections left. So we'll probably get through Gorsuch's in another couple of episodes. But so I want you to get a flavor for how this discrimination statutory construction goes. And one of the things I want to point out here is the term evil. Notice the word evil was used here when it talked about the Congress addressing an evil, right? So there's a moral aspect to this legislation, which is why people feel so strongly about it. It's supposed to reflect morality of a majority at the time it was enacted in 1964. And allegedly, that same morality governs today. Um, I'm just pointing that out. He used the word evil, right? Did you guys see that? Congress was trying to address an evil right here. The word evil. You see that? It's on 1744, page 1744, right here. Now, the citation up top is wrong. I just have to point this out. I'm sorry. But notice the citation up top. Google Scholar has this wrong. I do have to point this out because Google Scholar is making an error right now, and you have to correct an error when you see it. You see at top right here, it says Bostock versus Clayton County, Georgia, comma, 590 U.S. 644, Supreme Court 2020. That's the wrong citation here. That's not the pagination they're using. See that 644? They're saying that's the page number it started on. Now all of a sudden it's saying we're on page 1744. See that's the pagination they're using right here. So what the hell's going on here? Well, if you scroll up, you'll see there's two different citations. And the one at the very top says 140 Supreme Court 1731 2020. That's what they're citing. They're citing the Supreme Court reporter, not the U.S. reports. The U.S. reports is underneath. So if you're writing a paper on this and you're putting that page number in, that would be wrong. You got to be careful here. I'm just saying, you guys who you're used to using Google and you think Google always gives you the right answer, you're wrong. And you would be wrong. And I would count it off because I think that it's a bad student when you can't tell that Google has it wrong. That's exactly what I'm trying to get you to see is the computers do not always tell you the right answer. You guys, the computers are not in charge. Humans are supposed to be in charge. Okay? We're punting on first down to computers. It's first down. You don't punt on first down. You try several times, at least a few times. Okay? No excuses. Stop with the excuses, okay? Just take responsibility. If something doesn't match, you got to think about it. And this is in a context that's not where there's nothing for you to be really suspicious about. This is a mistake. But in a context where you're talking about something really controversial and you're relying on a computer to tell you the answer, you better have your radar on. Remember, the computer is not in charge of what the truth is. You got to find that out. You got to use your common sense. You got to have your BS detector on. And you got to be aware of what's going on here. Okay? Computers make mistakes just like people do. Sometimes the computer makes mistakes because people make mistakes. All right. So the word evil is used. But the word evil is a moral term. So we're trying to prevent immorality here. This is a very clunky way of going about it, I have to say. What could possibly go wrong? So I want that to be on your radar. Now, if we're concerned about evil, obviously the moral aspects of hiring women with young children should come into play somewhere, right? Unless you expect Congress to spell everything out in morality, and sometimes they can't do that. I mean, why would you expect that? Why would you expect a majority in Congress to tell you what is more moral for hiring women with small children? It's just so odd. Anyway, you have this here. He says, it's irrelevant what an employer might call its discriminatory practice, how others might label it, or what else might motivate it. He's saying motivation has nothing to do with the analysis of the evil here. That's what he said. Okay. You're saying motivation has nothing to do with discrimination. That's what you're saying. Okay. In Manhart, The employer called its rule requiring women to pay more into the pension fund a life expectancy adjustment necessary to achieve sex equality. What could possibly go wrong if you're trying to achieve equality? Okay. In Phillips, the employer could have accurately spoken of its policy as one based on motherhood. In much the same way, today's employers might describe their actions as motivated by their employees' homosexuality or transgender status. And that there you go. There's the status word. Status. To review, the big bug in this, it's not a feature, it's a bug in this decision. This word transgender status has all sorts of problems. First of all, what triggers this alleged status? Could a lie trigger it? A lie. And is lying relevant in an employee context? Yes and yes. That's a big problem. Apparently, all that is needed to trigger this so-called transgender special status is that you say something, and that's it. Is there a truth about transgender status? If so, what is the evidence of that truth? Can that evidence be faked such that there is no meaningful distinction between truth and a lie? Well, these are issues that are not even addressed, and they should be addressed. The other thing is they're squishing homosexuality along with transgender. Why are they doing that here? Why is Gorsuch and the Democrats doing that? There has been a movement, it's been called the alphabet people by some comedians, to include a bunch of different groups in the alphabet people to make it look, it's a political move. It's a political move to make it look like there's a big coalition of minorities here. So you have the T squished in there as if it's a natural part of this group. And people just start talking like this. I don't talk that way, but because I can see that it's manipulation. It's political manipulation. It's meant to try to show that there's a coalition, a political coalition here. But I'm not obligated to acknowledge a political coalition in my employment. Why would I have to do that? Especially if there's not a natural relationship among these groups. The so-called transgender status and homosexuality. That doesn't make any sense. Why there would be a coalition of that group. And just look at the words. You got lesbian, which means homosexual. So let's just call it homosexual. The H's. People don't like to do that because heterosexuality also starts with an H. So they might want to distinguish. But in distinguishing, they're creating two groups to make it look like it's more powerful. The men and the women, right? Did you notice that? That's by design. It's a political tactic. And then the next group is the B's, which has an affinity with homosexuality. Why would I say that? Because of the word sexuality. It's bisexuality, right? You got the women and the men, and then you got the bis, and bi means two. It can also mean both. Both. Both implies there's only two. So if I say, are both of your parents here? It implies you only have two parents. If you had 100 parents, and I said, are both of your parents here? It would sound strange, like you didn't know I had 100 parents. But the way humans are created, they have a mother and a father. Whether those normative roles are filled by those people accurately and morally is a different issue. Everyone has a mother and a father. And so the word bisexuality implies that a person could possibly or does actually find either one or both at the same time attractive sexually. So far, homosexuality and bisexuality, you can put them, I suppose you could put them in a political coalition. Okay, fine. But then lobbing on the T thing and then switching to the word gender, that's where things are starting to go off the rails a little bit. It's like, this is not a natural addition here. This is manipulation. This is political manipulation, cultural manipulation. Um, there's two sexes, and supposedly the sexual orientation issue is a stable and permanent condition. That's what we were told in order to change the definition of marriage. The claim was it's not fair if you're locked into this sexual orientation and you can't uh, marry who you want to marry. That was the claim. That was the language used. And my response to that was you can get married if you want, but you're falling into the situation where you don't want to get married. And I know you don't want to hear that, but that's the actual truth. If it is true, and it is, that marriage as a necessary condition has in its definition, its nature, at least a at least and at most two people who are of the opposite sex from each other. That's not the only condition, but it's two of the necessary conditions, the opposite sex requirement. Notice I said opposite sex because both are there, both. And the couple requirement, because if a thing and its opposite are present, there's two and there's only two. There's only two people in one marriage, right? You guys following that? Now, that's the classical marriage equality definition. All marriages, qua marriages, have at most two and at least two. That is to say, two people. And they're of the opposite sex from each other, male and female. There's other criteria too, uh, dealing with close blood relations, dealing with age, dealing with consent. dealing with humanity. Uh, those are implied in the terms male and female, man and woman. Um, the close blood relationship would not be included in the term man and woman, but those can be taken into account for issues not contradictory to the definition of marriage. Now, that's why I don't think that that argument worked for changing the definition of marriage the way it went down, because there was a lot of abuse, I think. Um, Calling people hateful when they just disagreed, that's abuse and manipulation. And the issue of I can't marry who I want to marry, well, it's it's not that you can't marry who you want to marry, it's that you're not interested in marriage. That's not what you're interested in, you know? If I don't like eggs for breakfast, but I do like sausage. Wow, this is okay, don't picture it, okay? Just or bacon, maybe whatever. It seems like I'm going to get in trouble no matter what I say at this point. Cereal. Um I'm just going to go with the sausage. What the hell? Patties, okay? Patties. I like hash browns, okay? And I complain that I can't call the hash browns eggs because you won't let me. And I scream and I call you hateful and I fight back and I say I can't have eggs for breakfast. And I would say, well, you could have eggs for breakfast. It's that you don't want to have eggs for breakfast. You don't like them. And you want to redefine the English language to make what you do like eggs when that's not really what they are. And you want to control how other people talk. Well, we covered that in the definition of marriage issue and take some time to unpack that. But there's also the race and sexual orientation analogy. We went through that. There's the issue of equivocation, which I just implied, and there's the issue of begging the question, which I also just implied. And we won't get into that. We're going back to the statutory construction with Gorsuch. Remember, he's a Republican saying this. I'm criticizing a Republican on the Republican Professor podcast. We'll go a little bit further here. So there's problems with transgender status, that term. It's doing a lot of work for him, and he hasn't shored it up. That sucker is vulnerable right there. It's vulnerable to the waves of time eroding it and basically dumping it into the ocean. I don't know why he didn't shore it up because to me, it's on sand. And I'm throwing some waves at it. I don't even need to throw waves at it. It's going to be hit by waves whether I do this or not. I'm just pointing you out so that you can get on board here. So we're at, but just as labels and additional intentions or motivations didn't make a difference in Manhart or Phillips, they cannot make a difference here. When an employer fires an employee for being homosexual or transgender, it necessarily and intentionally dis- I thought I thought motivation didn't matter. Okay, intentionally, you think it matters. Okay. I thought you said it didn't matter. Now you're confusing me. Now you're saying it does matter. Okay. It necessarily and intentionally discriminates against that individual in part because of sex. And that is all Title VII has ever demanded to establish liability. There's a lot there. That's all. So the in part thing, if it's 1%, then you've broken the law. According to Gorsuch, You find out she's a murderer. That's 99% why you don't want to hire her. But you also don't like she doesn't look good in high heels. That's 1%. And so he says, oh, you just violated the law. Now, I would say that common sense would be if she's a murderer and you have evidence of this, whether it's 99% or 100%, that's enough. It doesn't matter. It could be 1% and that's enough. But he's saying if you have any thoughts about her sex while you're firing her or while you're not hiring her or while you're not promoting her, then you are you're now you're screwed basically. That's what he's saying. No wonder people are so crazy in corporations because this stuff makes you crazy. The compliance mentality, when Congress takes upon itself to defeat evil, wow, that's a laughable. Isn't that laughable? Congress is going to defeat evil for us? Sure. And in 1964, they're going to defeat evil. Why, thank you. Thank you for that. So they're going to defeat evil by creating legislation and rules and regulations which are not complete. They're incomplete. Often they're not clear. They're definitely time bound in terms of the language used. And Gorsuch thinks he's using the language of 1964 here. Okay. Well, good luck. I mean, this is what you want for employment is to have every little thing dictated by judges or Congress? Really? All right. You think this is going to make the world a better place? I think it makes it worse. I have noticed so many crazy things in corporations, so many crazy things in HR departments, the crazy training they give you. Uh, don't get me started. Uh, I'm talking about corporations that are educational. To me, everybody seems to be walking around on eggshells. They're not really good people. And what I worry about is they think by complying, having this compliance mentality, they're good people and this is a good workplace. And really, everybody's miserable. And I don't think a good workplace makes people miserable. People are hiding things. There's no honesty. And I think a dishonest workplace is not a good place. I don't think that the evil has been defeated by Congress. I think it's actually only gotten worse. And I'm not blaming this on Congress. I'm blaming this on Gorsuch right here. Second, the plaintiff's sex need not be the sole or primary cause of the employer's adverse actions. See, this is the issue here. Need not be the sole or primary cause. In Phillips, Manhart, and on Kale, the defendant easily could have pointed to some other non-protected trait and insisted it was a more important factor in the adverse employment outcome. So too, it has no significance here if another factor, such as the sex the plaintiff is attracted to or presents as, wow, presents as, this language right here is weird. Presents as. Doesn't that require some kind of idea of what that sex is? What do you mean presents as? What does that even mean? Does it mean what I say, the words I say about myself? Is that what that means? What does that mean? Does that mean that I stuff my if I'm a woman and I stuff my pants full of tennis balls? I mean, what are you talking about? Like this is on sand. It's going to be eroded. I think it's already being eroded. It has nothing to do with me per se. I'm just pointing out that you might want to dig into that. You might want to just not take that for granted. presents as. To me, it sounds like acting. I mean, anybody who's seen a school play knows that the person isn't really Hamlet. They're presenting as Hamlet, but that doesn't mean they are Hamlet. And it also doesn't mean that I have to think that they're Hamlet. Presents as is the language of acting. It's the language of pretend. The language of attracted to is not the language of pretend. That's why I'm saying I keep going back and back to this. Homosexuality and transgender, they're not on the same team here. They're not on the same footing. I think the homosexuality uh, claim here is on stronger ground. I still don't think it's on as firm a ground as he thinks, but the the transgender presenting the so-called transgender assumption is, I think, on sand. It's on quicksand here. And you can have a straight face, but that doesn't mean that it's serious, intellectually serious, or it's morally serious, or legally serious. Here we go here. Yeah. So it so two, it has no significance here if another factor might also be at work. Again, let's talk about this in terms of percentages. Let's say 99% is and then there's like 1% has to do with I don't like that you're lying about your gender. And I don't think it's possible to change genders. So the lying is an issue. Uh he's saying um that has no significance here as far as avoiding liability. Just wanting you to know that that's what team you're on. If you're for this, that's the team you're on. Finally, an employer cannot escape liability by demonstrating that it treats males and females comparably as groups. As Manhart teaches, wouldn't that imply that these are natural groups? Like any natural group, like a group of trees would include the I'm saying trees on piece of property, for example, as opposed to shrubs, as opposed to grass, as opposed to flowers. Maybe trees have flowers. Okay. Well, as opposed to non-trees. Okay. Trees versus non-trees. But that's a natural grouping. Um, doesn't Are you saying these are natural groups that require an understanding of what the term means? Sounds like that's what you're saying. So that if you lie about a membership of that group, you're saying it's not relevant in an employment. That's what he's saying. That's what he's saying. As Manhart teaches, an employer is liable for intentionally requiring an individual female employee to pay more into a pension fund than a male counterpart, even if the scheme promotes equality at the group level. Likewise, an employer who intentionally fires an individual homosexual or transgender employee, in part, remember that could just be 1%, because of that individual's sex, violates the law. Listen to this language. Violates the law. It could be a percentage of 1%, and that would still be a part. Violates the law, even if the employer is willing to subject all male and female homosexual and transgender employees to the same rule. Again, I'm going to say what I said last time. If I have a problem with you lying about your gender, and I have that problem whether you're male or female, I don't understand why that wouldn't be sufficient to avoid liability under this statute, given what he said and given what we have here. Tell me if I'm wrong. Because lying is a moral issue and it is relevant in employer relationships. What do employers, now we're going to go through the first two paragraphs of Roman numeral III just to A, and we'll stop at A, okay? And then we'll be done for today. What do employers have to say in reply? For present purposes, they do not dispute that they fired the plaintiffs for being homosexual or transgender. Yeah, I don't think that I would have said that if I was the employer. I don't think I would have agreed to that language. Um, Sorting out the true reasons for an adverse employment decision is often a hard business, but none of that is at issue here. Rather, the employers, I'm like, seriously, guys. Rather, the employers submit that even intentional discrimination, I thought motivation didn't matter. Why do you keep saying intentional? Rather, employers submit that even intentional discrimination against employees based on their homosexual or transgender status supplies no basis for liability under Title VII. The employer's argument proceeds in two stages. Seeking footing in the statutory text, they begin by advancing a number of reasons why discrimination on the basis of homosexuality or transgender status doesn't involve discrimination because of sex. But each of these arguments turns out only to repackage errors we've already seen this court's precedents have already rejected. Yeah, I don't think so. In the end, the employers are left to retreat beyond the statute's text, where they fault us for ignoring the legislature's purpose in enacting Title VII or certain expectations about its operation. They warn, too, about consequences that might follow a ruling for employees. But none of these contentions about what the employers think the law was meant to do or should do allow us to ignore the law as it is. Now, let me say something in favor of Gorsuch and the Republicans on this majority. And I'm saying that way because I think the Republicans signed on to this for different reasons than Democrats did. So the Republicans split on Bostock versus Clayton County, Georgia in 2020. I think charitably amounts to this, that the ones in the majority, which is Roberts and Gorsuch, and you can't blame this on Bush, you people who hated the Iraq invasion and all that stuff and, so-called neocons or whatever. I don't use that language because I think it's highly confusing. I think you need to define what a conservative is before you start putting words like neo in front of it. Don't get ahead of yourself here. You got some work to do. Um, but Roberts was appointed by Bush and Gorsuch was appointed by Trump. They're Republicans on the majority, and there's Republicans in the dissent. The Republicans in the dissent are correct. But I do want to say something in favor of the Republicans in the majority. I know I've been nitpicking on Gorsuch here, but he's trying to get Congress into the game here. He look at this last sentence here in Roman numeral III, right above A on page 1745. He says, we are supposed to be applying the law the way it is. He's claiming just to read the text of the 1964 Civil Rights Act and only going by that and what it meant back then, he thinks you can get this result. Now, we've already poked holes in that, and we're not going to belabor that here anymore at the end of our hour here. But I want you to see the good part of what he's saying. This is a separation of powers point he's making. He's saying Congress has to be more specific if we're wrong. And Congress can fix this if we're wrong. That's what he's saying. And this was back in 2020. So, Congress, if you're listening, I'm talking to the guy, Congress. You say, why do you say a woman? Okay, I'm talking to the person, Congress. If it was a person, Congress, you can fix this. If you want to, you can fix it. I think Congress is so overwhelmed because the government is so freaking huge. It's a lot of agencies to keep up with, and you got a lot of constituents, both on the Senate side and on the House of Representatives side. Members of Congress, both senators and House members, have more on their plate than you can even imagine. And don't get me started with how little you really understand and imagine that. But what Gorsuch is saying is, if you really want to, you can fix this if it's a problem. And that's a separation of powers point that he's making. And as far as it goes, he's right. Thanks for joining me on The Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is 1 August, 2025 years after Jesus, even though the month of August is named after a very special Roman. We take our years from the Lord Jesus Christ. Take care. We'll see you next time.